Okay. Fine. Today we'll start that recap series. So we'll try to revise the current affairs for preliminary. So in these aspects. So in the first instance, we'll start with 2023 current affairs. So part by part, as we have already listed out some of the topics. So we'll go one by one. As of now, we'll start with polity topics, which were already in news. So some of the articles in the part one, what we are going to see is around 4. They are 370, 356, 29, 30, and 44. Right. Hope you would have revised something about these and come. Okay. So, and similarly, some rights which are fundamental. So that were also discussed. So especially we have right to silence, right to abortion versus right to fetus, and then right to contest in elections. So all these were in news, right? And some important judgments in 2023 related to these rights. So we can see one right to contest, which comes from Lily Thomas, and the Same-Sex Marriage Act, marriage judgment, which declined to approve the thing in India. So these are some of the important issues what we are discussing today. Okay. So first we will discuss some important under Article 370, and then we move on to some important judgments, and then we move on to the other areas. Okay. So about 370, so anybody can tell? So what happened? Why it was in news? So what was the actual thing behind?
Sir, it was basically whether it was a constitutional or not. Like the like we removed Article 3070 or like we amended. Yeah, whether it is it a constitutional or not. So for that reason, the case was filed, and like the Supreme Court declared that it's constitutional. Like the amendment was valid, basically.
Okay, fine. So anybody else? Anybody else want to add upon?
Sir, the removal of the case was challenged as that the removal of that Article 70 was not valid, but the court held that it is valid, not void. Okay. It is valid and it is temporary provision. Okay. It also cited that the legislative assembly of without permission of the legislative assembly of the Kashmir, without Jammu and Kashmir, the president can, if it is not in session, the president can remove that provision without the concurrence or consultation of the Constitution Assembly of the Jammu and Kashmir. So
okay. So anything else to be added? Okay. See, as you rightly pointed out, so 370 is a temporary provision. The Constitution itself is 370 is a part of original Constitution.
No, sir.
No, sir.
No.
Sir, after the instrument of accession, I think the provision was added to Constitution, so I thought it was not.
When original Constitution came into existence?
I think, sir, it was the part of original Constitution.
When it was adopted? So it was adopted in 1949. So 26 November 1949, you got it adopted. Okay. So when Article 370 was there, whether it is before 1949 or after 1951?
Before 49.
So it is well within the discussion of the Constituent Assembly itself. We inserted Article 370, and that is why we have Article 370. Otherwise, it would have been an amendment, right? So 370A or 371 or 2, likewise it will be. Okay. So it is originally a part of Constitution, because until in 1948, when it was acceding to India, instrument of accession was signed. So simultaneously, since the constitution was also under discussion in the assembly, so we had a provision for that. Got it? Whereas a similar provision, which was there to other states, which is under the article, under which article?
371.
371. So in that we have A, B, and so on,
A, B,
which are
C, yes, sir.
actually amended one. Okay, so which are there amended, whereas the others are already present. Okay, fine. So remember that it is not after that, it is within the constitution itself when it is promulgated. So we have this particular provision. So, but certain amendments were included in that. That is before through presidential orders in 1954 and all, we had certain provisions which are added to that particular 370. So through presidential orders. So that is another problem what it happened to be, because it was not a proper constitution amendment, but through only presidential order we have done. So that provisions also you try to have it. Whereas, as you know, I mean, the Supreme Court had clearly stated that it is well within the ambit of law, so it has been done. So remember, so we have Gopalaswamy Iyengar, who was instrumental in undertaking this particular Article 370. Okay, so it was a temporary provision in 1949 itself. So even in 1940, it was a temporary provision one. Okay. So similarly, you remember that in 2019 when it was done, so legislative of Constituent Assembly, I mean the Legislative Assembly of Jammu and Kashmir was dissolved. So that was a thing. So it was under governor's rule. So they had an easy choice of suspending it and try to use that particular governor's power in introducing this particular change in Constitution of India. Got it? So that was actually charged, but legally Supreme Court had upheld that it is not invalid. So you can uphold this particular thing because the process, in this process, Legislative Assembly was not actually present since it was not functioning. So the path in which it was done was okay. So in this way, what we have done, so we have done, I mean, we have certain special privileges which were there for Jammu and Kashmir has been done away with. Say, for example, property which is related to Jammu and Kashmir, where a special provision was there, only the citizens of the state can have it, whereas the citizens from other state cannot have it. Same way, financial emergency cannot be declared unless or otherwise it is approved by the assembly. So similarly, the ownership law, citizenship law, so many other fundamental rights differed with that particular thing, but all others are now into the particular state at the same level. But when we revoked it or when we did that, so what we did was we had a reorganization also simultaneously done. So what is that reorganization? So Jammu and Kashmir reorganization made the state into union territory. Okay. So for this, the Supreme Court clearly identified that it is legally okay, but it cannot be ethically right. For that reason, it advised the union government to revoke its this particular thing as soon as possible, though they didn't give any stipulated time. So they said revoking the what do you call the union territory state and putting it in the state of the state, giving the status of the state must be done as soon as possible, right? So that the elections and other stuff can be done. And similarly, remember that under this we had many territorial reorganization which also done. And in that particular territorial reorganization, you know that Ladakh was formed as a separate UT without legislature, whereas Jammu and Kashmir was a UT with legislature. Okay, so that is what the status what we have. So Ladakh had the larger part of the territory, whereas Jammu and Kashmir had a smaller part of territory and compared to land mass, but population-wise, you can find Jammu and Kashmir as more number of population. And similarly, take note of Article 35A also. They can also ask about Article 35A. And similarly here, public order and police. Okay, whereas for Jammu and Kashmir, land was also there, whereas here, only public order and police is going to be taken. Okay. So these are some of the changes or differences what we have as far as UT is concerned, because we have three important UTs with the legislature, that is Puducherry, National Capital Territory, and Jammu and Kashmir. Okay. All three have different status with respect to legislature. Okay, so remember that not all provisions are same. So try to understand the difference. Even in mains also, they can ask about this particular status of all the three. Okay, so understand the different powers of the legislature under these states, under these union territories, and different powers of the governors with respect to these union territories. Got it? Because NCT is also under news for various other disputes between the governor, union government, and the administration of the NCT. So in these aspects, they can also compare the powers of the legislature, compare the powers of the lieutenant governor, or compare the powers of the the lawmaking or administrative powers of these three union territories. Clear? So in all aspects also they can ask. And same way you try to remember the numbers. They can also ask the numbers. Last time there were questions related to the numbers of members of legislative assemblies and so on. They ask for parliament. Here they can compare all the three. Okay. So likewise also we can have. So these are some of the things which you need to do. And reportedly, the other aspect in Jammu and Kashmir, what you have as in news, is your delimitation. Okay. So along with that, you try to understand delimitation of Jammu and Kashmir also. Okay. How the delimitation is done, what are the issues there in delimitation. So all these aspects you try to do. Yeah. Fine. Okay. Now, so this is one important article where you have much more questions there. Then 356. So what do you know about 356?
State emergency, it is also known as president rule.
President's rule. Okay.
It comes under emergency provision.
So what is why or when 356 can be issued?
During when the constitutional machinery breakdown, so
we use the term breakdown of constitutional machinery. Okay. So
although,
whether
yes, sir.
So whether there is a role for governor in 356?
Yes, sir. He can advise to the president, or even without the president, even without the advice of the governor.
So president can impose with or without the report of governor. Okay, with or without the report of the governor. Even if the governor goes against the idea of the implementation also, it can be done away with. It is not a binding report. Okay. So with or without report, even if the report is submitted against the decision also, it can be done away with. Okay. So for how many months it can be put in place?
So the maximum limit is 3 years.
Maximum limit is 3 years. Okay.
So
after that, you need to have a conducive election. So normally,
the limit would
minimum
be
6 months to maximum 3 years.
6 weeks, okay.
That is the minimum. So maximum can be extended up to 3 years in one go.
Yes, sir.
Okay, in one go it can be of 3 years. After that, you must consult election commission to have election should be conducted. So when you implement 356, whether it is necessary to dissolve state legislature?
No, sir.
No, sir.
No,
Can
sir.
suspend or
Not
dissolve.
necessary. Okay. So you can have two options. Either you can suspend it, suspended animation, or you can dissolve it. Okay. So if you dissolve or suspend, you can have a governor's rule, that is a president's rule. So in this case, suspension means when the president's rule is revoked, immediately the legislative assembly will come to life. So automatically the government, in case if they prove the majority, they can sustain the government. In case if it is dissolved, So within the time period, you need to conduct an election. Thereby, after the governor's rule, there will be a government put in place. That's the only difference. Got it? Oh. So these are
Sir,
certain
one doubt, sir. Sir, like
under
maybe a
3
Supreme
6.
Court judgment.
Yeah.
Maybe a Supreme Court judgment is there, sir, like that we can't dissolve until it has been passed by the both houses. Initially we cannot
Floor
dissolve
test.
it. We
Yeah,
can
floor test
suspend
should
it
be there.
until.
And that's what. See, dissolution can happen if the floor test has failed. Right? So when there is a floor test happening and the floor test has failed, the government couldn't pass the floor test. Automatically, you can dissolve. Not a problem.
No, sir.
Right?
I'm asking in
So
the
nobody
like in
will
the
stop you.
parliament, sir. No, in the parliament, sir, like
See,
until
we are
it has not
see
been.
the parliament that is different. Whereas here it is 356, it is respect to the state, right? In the state, when there is a council of minister losing the majority of the house, it can be suspended or dissolved. Clear? Understood. Say breakdown of
Sir,
constitutional machinery can be of many aspects. One, losing the majority of the house.
Yes, sir.
Two, security of the state. There may be many other terrorist activity which is happening where the constitutional machinery has broken down. Some protection of the state. 355 has to be implemented. So for that, for 355, understood. So in that particular case, yes, definitely the state government may enjoy the majority in the floor of the house, but still we discuss the majority is there, but it may be suspended for certain issues. Got it? So for that only we have the famous judgment. So what judgment do we have with respect to 356?
KS
SR Bomai judgment 90.
SR Bomai judgment is there because we cannot suspend the house for just silly issues. So it has to be really whether it can be under Article 355 or under 356 Constitution Machinery has to be broken down. Then only you can suspend. In case of any floor test has failed, if majority is not working properly, then the resolution can be there. Got it? So 2930. So what are these rights all about?
The rights of the minorities to administer institutions.
29 and 30. 29. Educational rights, basically, right?
Yes,
So cultural and educational rights. Okay. So 29 provides for cultural rights, whereas 30 gives education. So why it was in news?
Sir, due to Aligarh Muslim University.
Aligarh Muslim University minority status. So whether Aligarh Muslim University enjoys minority status as of now?
No, sir.
No, right? So the Aligarh Muslim University, the case evolves like this. So the university was established under the Act of Parliament in 1920. Okay. So in 1967, there was a case called Aziz Basha case, in which the Supreme Court clipped the minority status for Aligarh Muslim University. So it lost its minority status during this time. Okay. It was argued that since this particular university was established through Act of Parliament and it was not established by the group of minorities, so naturally it doesn't have that particular act stipulating it as minority institution and so on. So the judgment said the degrees and other stuffs are valid, but only the minority status has been clipped off. Okay, that was the status since 1967. So to bypass this particular judgment in 1981, what they did an amendment. Okay. So they said under Article 30, it is said that it is just the right of minorities have the right to administer or take up the administration. So that administration need not be under the members of minority, but the minorities will be giving to some people who are in that particular affairs of the institution. So it doesn't mean that a minority. This particular amendment was just half of the way through, and it didn't have a complete invocation of 1920, what it was in 1920 Canada. So the actual issue is that in 1920, when it was established, and further, it was said that the Aligarh Muslim University was, the government says that the Aligarh Muslim University surrendered that particular minority status to the then British government. So you cannot have that particular minority status as of now. But this 1981 amendment, which was challenged again, and the case was there, and in 2005-6, the Allahabad High Court had annulled this particular amendment. So the amendment is not valid. So that was there, and the case is also there in the Supreme Court. Okay, so this is how the things unfold, and from that only, the case has one end to the Supreme Court. The other end is another PIL which was filed from these particular institutions, right? That they wanted to regain that particular minority status by challenging this particular Aziz Pasha case. So these are the two different cases which are there. So when Aziz Pasha case is there, if it is nullified, automatically the other set will be overruled. So automatically the other aspects of minority question will be resolved, and there will be the minority status which is resolved. I mean, acquired by the university. In case if the Aziz Pasha case has been upheld by the seven-member bench, then what happens? Then they will be taking up this particular 1981 amendment, whether this is going to be right or not. Okay, so this is how the case is, but the case is still pending. So the Supreme Court didn't have the haven't resolved yet. Okay, so it will be in near future before prelims, in case if the judgment has been done. So you need to clearly understand what the judgment is, whether they have restored or not. Okay, and what is going to be the case of Aziz Pasha case, the status of the case. Got it? So this is what it is. But as of now, these can be asked. So Aziz Pasha case can be asked. Otherwise, you can be asked with Aligarh Muslim University with respect to its origin. So originally, what it was before the university which was established, originally what was the name of this particular institution?
Anglo-Oriental.
Mohammedan Anglo-Oriental School was started, and then it became a college, and later in 1920 it became a university. Okay, and the two British principals, Thomas Beck and you can be asked with that, but anyway, that is remote fact. But origin it can be. So similarly, Syed Ahmad Khan, you need to remember, because he was the one who established this particular institution. Yeah. So this is one set. Another set they can ask Jamia Millia Islamia College. So they can just leave this Aligarh Muslim University. They can ask Jamia Millia Islamia College. What is this?
Sir, like
Jamia Millia Islamia.
Sir,
when it was started.
Like when the minority of the Aligarh Muslim University was revoked, then like we started.
No.
Okay.
When what is Jamia Millia Islamia College? When it was started, what was the origin behind it? When you came across this particular college during the freedom struggle?
Ali brothers.
No, non-cooperation movement you would have seen, right? So Jamia Millia Islamia College will be a part of education movement which was there in non-cooperation movement. Many new colleges were started during non-cooperation movement, right? So you had Kasi Vidyapith, so Gujarat Vidyapith, Bihar, many areas you will have colleges. Similarly, you had Jamia Millia Islamia, which was also started. Okay, so instead of this, they can ask this also. So in the history part, you try to have some idea on Jamia Millia also. So who were the founders, when it was established, what was the purpose of it, what is the difference between these two? Okay, so actually Aligarh Muslim University was favoring the Britishers. So they are just friends of British, whereas they were against British rule. Okay, so here Azad, Ali brothers, they were all associated in this particular institution. Got it? Maulana Abul Kalam Azad and others. So try to understand two different universities historically who are all present. They can just intermix and give the question. Clear? Okay. Now, Article 44, I hope you know. So, what is the reason for Article 44 in question?
Uniform Civil Code. So
That is for Uniform Civil Code. Okay. So, what is the news here? So, which state was in news regarding that?
Uttarakhand.
Uttarakhand. So, Uttarakhand was in news because of it became the
Uniform.
first state to have a Uniform Civil Code bill passed in independent India, right? So, the first state to have a Uniform Civil Code kind of was Goa.
Goa.
Right? So Goa was the first state to have a uniform civil code, but it didn't have a bill passed after independence. It was just a adaptation of Portuguese civil code. Okay, so they just adopted it and they have placed it. So strictly speaking, it may not be a uniform civil code kind of, which has been conceived for that particular purpose. But anyway, so this is the first state to have such arrangement, whereas Uttarakhand was the first state to have a bill passed in this particular uniform civil code. Okay, so this civil code is exempted for tribes, right? Exempted for tribes. So some important provisions regarding that you try to have it. So I don't suppose they will ask the provisions, but anyway, some facts regarding uniform civil code can be there. Okay, so when it was first tried to be introduced, or what are all the basic origin? So that particular type your questions can be there. So the most importantly, what is uniform civil code? Where, what it is going to be targeted? Those aspects they can ask. Okay? So anyway, this is how the idea is. So apart from that, in mains, you can expect a question. More than a prelims, I think in mains, they may focus on uniform civil code. What is its significance? Why or why not? So those type of arguments, it can be clear. But here, some basic facts of civil code. So what it can be amended, or what civil code actually consists of. So which state or Goa and Uttarakhand they can compare. So what type of things they have. Say Goa, bigamy is allowed, whereas Uttarakhand it is monogamy. Right? So likewise, some differences are there. So that can be asked. So likewise, the questions will be presented. Okay. Yeah. So sedition. So what are the issues with regard to sedition? So actually two important thing. One, sedition with respect to law commission. So what law commission told about sedition? Okay. And what Supreme Court told about sedition? And what the newly amended laws, that is, you have the new replacement laws, right? So IPC is going to be replaced, and CRPC and this one, that is Evidence Act. So these are replaced. So what sedition is there in this particular act? Okay. Though the word sedition is not there, the sedition clauses are there. Okay, in the new replacement acts. So Supreme Court, they said they wanted to take a call on sedition. So they have taken an opinion on this particular issue with the Supreme Union government, but the case is still there. So we haven't closed it out. Okay. So still we have the validity over sedition. Okay. Right. So try to learn about what are the different constituents of sedition. Say, for example, speaking, sedition through speech, words, letters, insignias, or pictographic representation, all can be there under sedition. So understand the difference between sedition and criminal defamation. So that can be asked. So sedition versus defamation. So what is sedition? So there are certain things which are in news, so they can also relate it and ask you. So sedition, hate speech, okay, and defamation, and criticism. Okay. So what are these aspects, okay, with respect to freedom of speech? So freedom of speech versus sedition, freedom of speech versus hate speech, defamation, and criticism. Okay. So all these aspects you try to find the linkages and difference between all these. So what it is, and the new law also have some definitions related to hate speech also. Okay. So try to correlate everything and have a simple understanding of all these. Okay. So this will give you a better understanding about the issue. So because in case if they want to have mass following with the definition kind of, or just an explanation, say last time they asked state, define state. Likewise, which one of the following aptly defines hate speech? Okay. So likewise, there can be questions. Okay. So that type of question you try to have it. And similarly, sedition, we have IPC. So regarding to sedition, but it is actually an amendment which was inserted by the British. It was not in the original IPC format. Okay, so all these aspects. So similarly, defamation, how it happens to be a reasonable restriction there. So all these aspects you try to put in place under reasonable restriction, which is an offense, which is a restriction. Okay, so type of question varies. Accordingly, you need to understand the concept. Okay, so what are restrictions? What are offenses? Okay, so where I can be charged, say defamation is a restriction, but I can be even charged over it. So civil or criminal. Accordingly. So criticism is neither a restriction nor a offense. So critic, what is the difference between critic and defamation? So how it differs? So that is how the basic differences you try to understand. Clear? Because with the words only they will play in these questions. Clear?
Sir, one question, sir. Like the newly, like the law which has replaced the IPC and all, like, sir, is it applicable from now, like after, like now, is it applicable in India, sir? Or will it go phase wise, sir?
See, the entire law will be applicable only from June 2024.
Okay.
That's how they said, right? So after June, the rules and everything will be put in place. Till now, the original, the previous one will be gone. Yeah.
Sir, like they said that they have removed sedition. Now the sedition is not there in newly law.
And that's what the word sedition is not there. I mentioned it right, I suppose. So word sedition is not there, but the provisions of other aspects in other words are there.
Okay, sir.
So it is in different format. That's all. Then, similarly, right to silence. Say right to silence. Even Supreme Court reiterated again that the accused has the right to silence. Okay, so under Article 20 Clause 3, the state cannot force a person to be witness against himself. Okay, so under this, right to silence is upheld by the Supreme Court, and it had clearly mentioned that right to silence is available to the accused. Okay, so remember that. So read Article 20 Clause 3. So generally Article 20. Okay. And similarly, abortion right versus right of fetus. So recently, Supreme Court clearly mentioned that after 24 weeks, okay, say up to 20 weeks, no problem of abortion. And the recent judgment is any women can abort. Question of law then. Okay. So because previously it was said that married women kind of, but Supreme Court clearly mentioned that whether it is a single or married or any adult woman, they have their consent up to 20 weeks. So 20 to 24 weeks, there are certain conditions. 22 weeks, there is one condition, 24, there is one condition. Beyond 24, so the question came in. Okay, beyond 24, so Supreme Court invoked the right of fetus. Okay. So less than 24, there is no right of fetus, but beyond 24, the Supreme Court said, though WHO doesn't have, remember, WHO doesn't have right to fetus. Universal Declaration of Rights doesn't have, that is human rights doesn't have right to fetus. Whereas in India, Supreme Court has said there is right to fetus to be considered after 24 weeks. Right? Remember that. Okay? So it should be done only under the certain conditions where really the mother's life is under question. So then only the right to, fetus will go away and right to abort is put in precedence. Understood?
Sir,
India doesn't have right to. India does not have right to bodily integrity for women. Okay, we haven't have bodily integrity to women. There is no right which was prescribed as fundamental. But right to abort becomes a right under a legality of MRTP. So under that, 20 to 24 under instructed abortion, whereas beyond 24, so right to fetus comes into picture. That's idea. And right to abortion is there for any woman. Remember that. That is a Supreme Court judgment also recently. Fine.
Sir, what did you say, sir? Bodily, sir, can you repeat it, sir? You mentioned that in the women that don't have the
bodily integrity. That is, women having the right upon their body in an integrated way. So we don't have that particular right recognized in India. But right to abortion is recognized as a legal right under MRP. But right to fetus comes in after 24 weeks. So in case a woman want to abort a fetus after 24, it will be very difficult because Supreme Court said that we need to consider the right of fetus also. Clear? It is not that it is not possible, but there are a very heavy checks and balances which have been implemented.
So even for 20 weeks, sir, do we need
no, less than up to 20 weeks, no problem. 20 to 24, there are guidelines which are provided by the Act itself.
Okay, sir.
Right?
Okay, sir.
Okay. Then comes a right to contest and Lily Thomas versus Union of State. That is where the thing comes in. That is your the MP disqualification, which happened with Rahul Gandhi and others. So where they had the problem in this particular regard. Yeah. See, what is Lily Thomas case?
Sir, it was about that they did some amendment that if they can file a case in High Court and after within 3 months and all, and then they can contest the elections, something like this. And it was violating the right
the issue is that actually the right Representation of People's Act mentioned that when there is a crime or an offense which was committed by an elected member of a parliament or legislative assembly under, say, Prevention of Corruption Act. So if they are convicted for within 2 years and above, then automatically they will be disqualified. Okay. So to be the member of parliament or assembly. So in 2013, they amended that particular provision. And in that provision, what happened? It will not be immediate disqualification, but it will take around 3 months of time. Okay. They wanted to give some 3 months of time. So Lily Thomas case in 2013, they clearly argued that, say, the very purpose of this particular amendment or this particular provision in RPA was to decriminalize the political ecosystem. So, but this particular provision of 3 months is going to be waiting period for disqualification will be amounting to doing injustice to that particular noble objective. So Supreme Court also took up that argument and they nullified that particular amendment. So any disqualification will take with the immediate effect unless or otherwise the sentence in the conviction is stayed. Okay? So both the sentence and the conviction has to be stayed. Unless or otherwise it will be immediate effect will be taken. But this is the present condition also. No change has been there. So really Thomas case is absolute. But the thing is, when the current scenario comes in, so this takes up a route of disqualifying people just because of having false allegation and having a problem of, criminal is, invoked again. So there are many scenarios where the cases which are taken up with a judgment of or conviction for around 2 years and above. So now that is taking up into consideration. So that is where this particular case came in. So the recent case was the Rahul Gandhi's case, where he was convicted for a defamation, and 2 years defamation was there. Punishment for the defamation was done, and immediately he was suspended. So the question is, how far this particular defamation as a case for disqualification of an MP is going to be, because in RPA, it is very clearly mentioned certain list of acts are there, and similar kind of those notorious crimes are listed, under which one can be disqualified. Whether defamation also goes on par with these list of crimes or offenses is a question of law. Okay, that is where the question comes. Okay. So, because in one sense, we are trying to decriminalize defamation, and same defamation acting as a cause for disqualifying an MP. So that contradicts each other. So that is where the point of law comes in, where the Supreme Court tries to take a decision where the case is still pending, and similar such cases are still pending. So we need to wait till the judgment comes. So what the Supreme Court actually comes up with that. But here the question will be on here the right to contest is curtailed. Okay, so right to contest is curtailed with respect to this Lily Thomas case. Okay, fine. So here the question will be on how the disqualification can happen. Okay. Disqualification of an MP or an MLA who is elected directly, how this disqualification happens. So the disqualification happens through the constitutional provisions which are already provided in the constitution, like say if the citizenship is revoked, that is surrendered. If the MP or MLA is not a citizen, unsound mind, and so on in 105, what all the lists they have, these are. In these also, they have some disqualification prescribed. Okay, insolvency and so on. Other thing is 10th schedule. Okay, another disqualification is 10th schedule. The other set of disqualification comes with RPA, that is Representation of People's Act. In that, two types of things are there. One, electoral offenses, where you don't, misinformation regarding expenditure or sectarian speeches under which your candidature is disqualified. Likewise, there are list of electoral offenses. Other thing, disqualification based on certain offenses under various acts. And that is how you find that raising sati, dowry issues, domestic violence issues, so heinous crimes like rape, terrorist activities, all these. So offenses under certain specified acts, so which has instant disqualification. Okay? Instant disqualification. Say for example, sati and all, it will be instant disqualification, right? Sometimes there are certain offenses, but if the conviction is less than 2 years, they will escape, or convictions which are more than 2 years, then they will disqualify. Okay, they will be get disqualified. Understood? So disqualification of MP can come in two different modes. One through constitutional provisions, The other one is through RPA. Okay. Through constitutional provision means there is a list of disqualifications which you have provided in the provisions of the Constitution, and then in case defection happens under anti-defection law, then automatically 10th schedule you will be disqualified. Otherwise, under RPA, when you commit an electoral offence, you will be disqualified. Okay, or else there are offences which are prescribed. In case certain offences, instant disqualification will be there. Certain offences, in case if there is a conviction which is more than 2+ years, then automatically disqualification comes. Understood? In case prelims, remember very clearly what provision they are asking. Okay? Under which of the following provisions of RPA a person can be disqualified? Okay, in case if it is there, say 10th schedule and all, it is constitutional provision, not under RPA. Okay, so likewise there are same disqualification. The disqualification can be right, but it may not be under that right provision. Okay, accordingly you need to remember and say it. Okay, in mains if you are going to write, you need to write it clearly. So various processes in which disqualification can happen. Okay, so one, through constitution in this particular article, this is a particular case. Then in 10th schedule, this is a case. Then under RPA, these are certain cases. And under RPA, there are other areas where they. So when you need to make it clearly. Understood? So remember them. These are very nuanced issues which you need to remember under disqualification. Right? Similarly, whether the disqualification of president or governor in those cases, so what speaker has to do, so related powers also, you just check it. Then the judgment which declined to provide recognition to same-sex marriage in India. So again, that is one important judgment which happened. It's a constitutional judgment, 5-judge thing which happened. So the full notes you can just get it in the in our Insta page or FB page. You can just check it out. The issue number 52. So here you need to remember that certain things are available to general couples, whereas certain things are not available to same-sex couple. Legal status for the same-sex couple is not possible. So that is what the recognition was not provided. Same way, right to marriage is not a fundamental right under the Constitution. Remember this also. Okay? So right to marriage is not a fundamental right, which has court has clearly declared that. But right to choose a partner is a fundamental right. Okay, right to choose partner is a fundamental right. Remember that. Okay. So right to choose a partner is a fundamental right. Right to consensual sex is a right. Okay, it is not a right denied to anybody. It is a right available to everybody. So that is also a case. Which had which under section 377 judgment. It is clear consensual sex is a right of an individual, whereas marriage is not a fundamental right. Marriage is not a fundamental right. And similarly, right to adopt again is not a fundamental right. And transgender, they have right to marry. Okay, but that right to marry is not again a fundamental right, but they have the right to marry because it is not about that particular same-sex kind of. Got it? So they have clearly had the difference. So this is, remember that these two are the basic difference. So when they ask, they may have two statements. Who are all say transgender persons along with same-sex couples doesn't marriage? No. So they have the right to marry. What to have? And similarly, they both are not enjoying right to adopt. Where the right to adopt is enjoyed by a couple, heterosexual couple, right to adopt is not enjoyed by these two. Okay? So these are certain changes or certain differences which you need to remember, okay, which is available to general public, which is not available to same-sex couples or transgenders. So all the three. So how it is going to be. So that is important. Got it? Okay. So here you need to remember that Special Marriage Act. So even for Uniform Civil Code, this is important. Okay, Special Marriage Act is important. And clearly the Supreme Court said that you cannot replace the gender neutral term. So unless or say why Supreme Court didn't give this particular right, because they said clearly law is not permitted. When law permits, you can have. How the law comes in, center or state, they so Supreme Court said it cannot create a law, so it cannot insert a gender neutral language. Okay. So the burden is shifted to the government. The state or the center can make their judgment accordingly to provide the law enabling the rights to the same-sex couples or transgenders in other aspects. Okay. So here, these two judgments comes in this particular case also. So one is private, privacy right. Another one is which decriminalized consensual sex among adults. Okay. So remember these. The confusion comes which is fundamental, which is not, which is available to one, which is available to the not available to other. So these two are to be understood. Otherwise, that will be the point of confusion where you may skip that particular question or you may end up marking wrong answers. Yeah. Understood? So any
Yes, sir.
doubt in these?
Yes, sir. No, sir.
Okay. Fine. So in the next class, we will try to have the other aspects of these discussion, right? So similarly, try to move forward with the other part of the polity topics. So we'll discuss it in the further classes. Okay.